Losing a life partner is absolutely heartbreaking. Your entire world feels like it has come to a complete standstill, but simultaneously, something else begins. A timer, a 9-month timer with the IRS, and what the majority of people are unaware of regarding this crucial window can genuinely cost them everything they've worked to build. So let's dive into what you absolutely need to understand. This is information that every single person should honestly have access to, yet almost no one ever discusses it. And look, this isn't just some theoretical scenario. Let me walk you through the real-life story of a 71-year-old widow from Pennsylvania. Her husband passes away. They had lived in their home since 1990. The mortgage was fully paid off. Everything appeared to be in order. She believed, I'll be just fine. She didn't sell the house, didn't touch a single account, but then 9 months later, without warning, an official notice from the IRS arrives. She owes over $6,000 in fees. And the most painful part, she lost access to a tax exemption that could have shielded more than $13 million. All because she missed a deadline she never even knew was there. That is precisely what we are here to prevent. We are going to make absolutely sure that doesn't happen to you. This is the number you need to engrave into your memory. 9 months? The countdown begins the very day your spouse passes away. And the IRS, well, they simply do not pause for grief. What you do, or more importantly, what you fail to do within this narrow window, makes all the difference in the world. It's the difference between safeguarding everything you have built together and watching a substantial portion of it disappear into taxes and penalties you never even knew existed. Okay, so here's how we're going to approach this. First, we'll cover the 3 major financial pitfalls to watch out for. Then, we'll move into the valuable stuff. Protecting your home, preserving your estate, and securing all your remaining assets. And we'll bring it all together with a final, crystal clear action plan. All right, Section 1. Let's truly dig into why this matters so enormously. It isn't just one minor issue, it's actually a perfect storm of several different risks that, honestly, most people have absolutely no idea are approaching until it's already far too late. So what are these pitfalls? There are essentially 3 major ones. First, you have the IRS. They require a federal estate tax filing, or at least a documented decision not to file within those 9 months. Second, you have your state government. Many states have their own estate or inheritance tax, and guess what? Their exemption thresholds are dramatically, significantly lower. And third, and this is a major one, are your own missteps. Simple errors and simple oversights can trigger enormous, completely avoidable capital gains taxes further down the road. We're going to walk through how to avoid all 3. Okay, let's begin building our defense. And we're going to start with the single biggest asset for most families, the home. This is ground zero for the most common and most financially damaging mistake, but it's also where you'll discover one of the most powerful tax advantages in the entire system. So, there's a term you absolutely need to know. It's called stepped-up basis. It sounds technical, but it's genuinely your greatest ally. This is arguably one of the most valuable and most overlooked provisions in the entire tax code. Here's what it means in straightforward terms. The IRS essentially hits a reset button on your home's value. They treat the house as if you purchased it for whatever it was worth on the exact day your spouse passed away. All those years, perhaps even decades, of the home appreciating in value, gone. For tax purposes, that accumulated gain simply disappears. Let me show you what an enormous difference this actually makes. Consider this example. Suppose you purchased your home years ago for $120,000. Now, on the day your spouse passes, it's appraised at $450,000. Okay? If you didn't have this step-up provision and you sold the house, your taxable gain would be a substantial $330,000. But with the step-up, your new cost, your new basis is reset to that $450,000. So if you sell it shortly afterward for, say, $460,000, your taxable gain is only $10,000. I mean, the difference is truly extraordinary. So what does that actually translate to in your bank account? In that specific example, that single provision could save you approximately $50,000 in taxes just from having the correct documentation on file. One straightforward action can genuinely protect a lifetime of carefully accumulated equity. It's incredibly significant. Okay, so how do you demonstrate this to the IRS? You can't simply estimate, right? This brings us to action step number one. You need to obtain a formal date of death property appraisal. Hire a licensed appraiser, ideally within 60 days. It will run you maybe a few $100s, but that report, that is your golden ticket. It's verifiable, concrete proof for the IRS. This is something that affluent families do automatically. Their attorney simply orders it. It's time the rest of us were aware of this approach. All right, so we've secured the home. Now let's take a broader view and examine the entire estate. This is where that 9-month countdown truly comes into play, and it all revolves around one specific IRS form. So that 9-month countdown we keep referencing, it's the deadline for something called IRS Form 706. That's the federal estate tax return. And right now, you're probably thinking, wait, the estate tax exemption is around $14 million. I'm nowhere near that threshold. I don't need to file. And that assumption, that single thought, is a multi-million-dollar mistake just waiting to unfold. Here's the trap. You're thinking, my estate is under the limit, so filing isn't necessary. But here's the reality. Submitting that form isn't about paying taxes today. It's the only mechanism available to capture your deceased spouse's unused exemption and transfer it to yours. It's a concept known as portability. Think of it this way. Your spouse has a $14 million voucher, and if you don't file this form, you essentially throw that voucher straight into the trash. It disappears permanently, and you've just forfeited access to millions in future tax protection. Which leads us directly to step 2. And you need to act quickly within the first 30 days. You need to consult a professional, a CPA, or an estate attorney, and ask them one specific question. Should I file Form 706 for portability? They will help you evaluate your situation. And if the answer is yes, you absolutely must get it completed before that 9-month window closes. Do not let this slip by. All right, step 3. This one is straightforward, but critically important. You must update the title and deed to your home. You simply need to officially remove your spouse's name from the documentation. Visit your county recorder's office with the death certificate. It's a routine filing that probably costs less than a nice dinner out, but it will save you thousands, and I genuinely mean thousands, in legal complications later if you decide to sell the property or refinance. So let's say you've got all your federal matters in order. You're feeling confident. You might be protected from the IRS, but are you protected from your state? This is the question nearly everyone neglects to ask. Just because you're clear with the federal government doesn't mean your state won't come looking for its portion. And this is an enormous trap. The federal exemption is, nearly $14 million. But states operate under entirely different rules. Consider Oregon and Massachusetts. They begin taxing estates valued over just $1 million. And remember that widow from Pennsylvania? That state has an inheritance tax that applies from the very first dollar. There is absolutely no exemption. This is precisely how ordinary middle-class families get completely blindsided. And here's the critical detail. Many state deadlines are actually shorter than that 9-month federal one. You must stay on top of this. Okay, so we've addressed the home, we've addressed the estate, but there are a few more genuinely critical details we need to cover. Let's make sure we protect all the other assets you've dedicated so much effort to accumulating. This brings us to step 4, and please do not overlook this one. You need to conduct a thorough review of every single beneficiary designation you have on file. I'm talking life insurance policies, IRAs, 401ks, absolutely everything. And here's precisely why this matters so much. A beneficiary designation overrides your will. Let me repeat that. It overrides your will entirely. It doesn't matter what your will states. If you have an old 401k from a position you held 20 years ago that still lists a former spouse as beneficiary, that person receives the funds. Not your children, not your estate. That individual does. Taking 1 hour to correct this can prevent an absolute disaster for your family down the line. And last but certainly not least, step 5. This is one that can actually put money back in your pocket every single year. You need to contact your county assessor's office. Ask them specifically about property tax relief programs available to a surviving spouse or widow. Virtually every state offers some type of program. It could be a reduction in assessed value, or it could be a tax rate freeze. But here's the critical thing. These benefits are not automatically applied. You must submit an application. And if you don't, you could be overpaying your property taxes by thousands of dollars every single year, year after year. Okay, I understand that was a significant amount of information, so let's bring it all together. Let's consolidate everything into one straightforward final action plan. This is your 9-month checklist, your complete guide for navigating this period. Here it is. Beautifully simple. Step 1, obtain that property appraisal. Complete it within 60 days. Step 2, consult a CPA regarding Form 706 and do it within 30 days. Step 3, update the home deed. Allow yourself 60 days for that task. Step 4, review all your beneficiary designations. Another 30-day priority. And Step 5, apply for those property tax relief programs before whatever your specific state's deadline happens to be. That's the complete picture. This checklist right here, this is the entire game plan. The distinction between someone who successfully protects their family's financial legacy and someone who doesn't comes down to this. It's not about how much wealth they have accumulated, it's about knowing and executing these 5 steps. So, I'll simply leave you with this final thought. You've dedicated a lifetime to building something meaningful together. Are you truly prepared to protect it? The most important action you can take right now is ensuring that legacy remains completely secure. And please, if you know anyone who genuinely needs to hear this message, pass it along to them. Don't let that 9-month clock catch them completely off guard.